The company holiday party is designed to feel festive and obligation-free, but the combination of an open bar, social pressure from bosses and colleagues, and a drive home at the end creates a predictable trap. People who would normally stop after one drink find themselves several in, not because they made a reckless choice, but because they went along with the room. That is the human story behind a large share of December DUI arrests in California. One of the more important scientific facts in these cases is that alcohol takes time to absorb. If you had your last drinks near the end of the party and drove shortly after, your blood alcohol may have still been climbing when you were behind the wheel. The test taken later at the station, which is the Title 17 governed result the prosecution relies on in court, could read higher than your actual level at the moment you were driving. That gap between when you drove and when you were tested is called the rising BAC issue, and it is a real line of defense worth examining. December is one of the most active DUI enforcement periods in California, with extra patrols and sobriety checkpoints running throughout the month. But a high volume of stops does not give officers a pass on the rules. They still need a lawful reason to pull you over. The field sobriety tests still have to be administered correctly, and the chemical test still has to meet the reliability standards of Title 17 of the California Code of Regulations. In fact, the rush of holiday stops can make procedural mistakes more likely, and those mistakes are exactly the kind of thing a defense attorney looks for. If you hold a professional license in California, a DUI arrest adds a layer beyond the court case. Licensing boards in many professions have their own reporting rules and their own authority to discipline. The reporting requirements and consequences vary by profession, so it matters which board oversees your license and what its specific rules say. The right way to resolve the criminal case, and whether a reduction or other outcome is realistic, should take your licensing exposure into account from the very beginning. Whatever happened at the party, the first practical step is the same in every California DUI. You have 10 days from the date of arrest to request a DMV administrative hearing to protect your driving privilege. That deadline does not pause for the holidays. If you miss it, the DMV will automatically suspend your license without any hearing. 10 days goes fast in December, so confirm your deadline as soon as possible. People arrested after a work party are often genuinely responsible individuals who misjudged one night in an unusually pressured social setting. A steady job, a clean record, and a single lapse at an event you felt obligated to attend create a sympathetic picture, and that picture is part of the human context a defense brings forward in negotiation and at sentencing. The arrest can feel especially humiliating when colleagues were present, but the embarrassment is not the legal case. The case turns on the lawfulness of the stop, the reliability of the tests, and the evidence, and those technical questions often look better on review than the night of the arrest suggested. Results vary, but a defensible case is defensible regardless of where the night began. If your December ended with an arrest, take a breath. You have real options, and the case is worth examining carefully. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.